Hi, welcome back to part 2. I am your host, Attorney Michael Potter, and in this segment we're going to continue our discussion on how best to hold title to real estate. Now, in our last segment, we talked about holding title to real estate in a few ways, such as individual ownership, even if you're married, joint tenancy with rights of survivorship, tenants in common, and community property. In this segment, we're going to look a little more deeply at some of the other options to see what opportunities they may hold for you. Now, in certain states, you can hold title if you're a married couple as tenants by the entirety. And this can be very advantageous. It gives the advantage of automatic transfer to the other spouse in the event of death, and it also restricts either spouse from making a transfer without the consent of the other. That can provide some asset protection in the event of a lawsuit. So in that way, it could be very advantageous, but it's not available in all states. Now, another way to go is to hold title in the name of your living trust. And this can give you some distinct advantages for estate planning and flexibility. For example, if you become disabled and you can't function, then your successor trustee, whom you have named, can step into your shoes and handle things for you. Then when you recover from that disability, you're back on your feet and you're okay, you can take back over as trustee and continue to manage your own living trust, just as you did before. So it gives you a lot of flexibility there. In addition, in the event of your death, the property is transferred to whomever you say, according to the terms of your living trust. Of course, you're going to want to pick a reliable trustee, someone that you have confidence in, who has the personal integrity and the personal honor to follow the instructions of the trust. Now, the trustee does have a legal obligation to follow those instructions, so usually you're in pretty good shape, but it's important to pick a good trustee. Another thing to consider when you're using a living trust is to have a successor trustee, maybe one or two. I often recommend that my clients in my law firm use successor trustees so as to protect themselves. So if something happens to you as the primary trustee, you've got a backup. Well, what if something happens to your backup? I often recommend that clients for my law firm use more than one successor trustee. I like to use 2 or 3 successor trustees depending upon the situation. That way the successor trustee can step into your shoes and make distributions according to your wishes, and that way it can be distributed in the way that you want. Now, for many years, a lot of clients who are investors are concerned about privacy, and they can certainly hold title to real estate in a land trust, or what we call in our office the real estate privacy trust. This is a method of ownership where you select a trustee, maybe a sister with a different married name, and she can step in and be trustee and hold legal title to the property, but she cannot transfer it or do anything with the property without your permission. And the use of the land trust or real estate privacy trust is a very effective way to go. Where title is held in the name of a real estate privacy trust or land trust, as it's generically called, the trustee that you've nominated may not make transfers without your directive authority. And secondly, upon your death, the trustee must follow the instructions of the trust and make distributions to your heirs according to your instructions. Now, what about the use of a corporation or LLC to hold legal title to property? That can be a very effective way to go, but you need to combine the use of the LLC or corporation in such a fashion that it works with your estate plan. For example, I have many clients that over the years have been involved in residential redevelopment, also known as fixing and flipping a property. Where you're flipping properties, a Subchapter S Corporation could be a way to hold legal title. It will give some tax advantages and some asset protection advantages, but that corporation needs to be part of your estate plan. The same is true if you hold title to a property that you've invested in the name of a limited liability company or limited partnership. Either way, you want to have that title connected to your estate plan so that in the event of your death or in the event of a lawsuit, you have some protection. Many times people will combine the use of a land trust with an LLC so that they've got the elements of estate planning, privacy, and asset protection. Now, any of these methods can be very useful depending upon your circumstances. Now, I know that there are many people around you who think they know what they're talking about, and they do mean well, but they're not licensed necessarily to give you legal advice. This is a legal matter, and you need to work with an established law firm that has the competency and the licensing to properly guide you in this way. If you'd like more information about your options on how to hold legal title and you'd like to have a legal consultation, get in touch. We'd be glad to hear from you. This has been part 2 of our 2-part series on how to hold legal title. I'm attorney Michael Potter, and I look forward to hearing from you.